everyone. This is Glenn House of Fern, and you're listening to These Changing Times radio station, and the program is called Do You Know Who You Are? We're talking about land titles today. We started talking about it yesterday, and we're going to finish it up, and we'll move on to something else. The reason we're calling it Do You Know Who You Are is because I was visited by the Texas State Police and the FBI about a year ago last March, and at that time they told me that I'm listed as sovereign in their system. So this program is about how anybody can do what I did and how to do it and what's really going on. You have to understand that everything is an illusion. And once you understand how this is happening and what's going on, it's easily defeated. But you have to know what's happening and how it's happening before you can do anything. And so today we're talking about land titles. And I have absolute title to land in Arizona and Texas. And but invariably some clerk or some criminal decides to violate my rights and try to steal my land and convert it over to their use so they can charge me an annual fee in the form of rent in their so-called taxes. And so I've been getting pretty good at that now, and so I'm in a little battle right now with Navajo County in Arizona, and I think I'm going to get some people in jail. And so we'll see what happens, but I've got a document that I'm getting ready to criminal complaint. I'm getting ready to record, and then I'm going to send it to the Arizona Attorney General and demand that he jail his hired thugs, and we'll see how that goes. But anyways, so we're talking about land titles today, and we are all products of the government's educational system. And the government has taught us what we need to know to operate in their system, but have they taught us everything? And absolutely not. There's a lot of hidden knowledge out there. We talked about that in some other presentations about the occult. Occult is a word that if you go to Wikipedia, you'll find out that occult means hidden knowledge. When I was a kid, I was always told that occult was something real bad and evil and all that stuff. Well, I guess I don't believe it is evil, and it's just hidden knowledge, and that's all it is. And so do you know who you are? The powers that be are keeping this knowledge hidden away, although it's really not that hidden. You just have to look for it, and it's right there in front of you. It's all over the place. But if you know who you are, then you can be the king or the queen. But otherwise, you're a slave, and there's nothing in between. Either you're the king or you're the slave. And a good example is this recent Obamacare. Okay, if you read some of the stuff that they're going to be doing triage. Matter of fact, I call the healthcare system a death care system because the whole idea of the death care system is that they manage your death in such a way so that they can make as much money from it as possible and reduce the population at the same time. And that's exactly what that's all about. So I rarely go to a doctor, and I use alternative remedies, and I find that they work way better than anything a doctor can do anyways. The things that the doctors say are terminal. My sister-in-law cures cancer on a regular basis, and she's an herbalist. And as a matter of fact, the local medical doctors in her area send her their terminal relatives. They don't send any of their patients. They're just their terminal relatives because they don't want to lose their relatives, so they don't care about anybody else. But so the point is that there's all sorts of hidden knowledge, and health foods and alternative remedies is one of them. And if that's evil, well, I think I think that what that comes back to is in the Bible it says, "Woe unto those that call good evil and evil good," because in my opinion that's good. And our alternative remedies were provided for us. They're just normal. Many of these herbs are considered weeds. They grow all over the place, and all we have to do is learn how to use them. So, anyways, today we're talking about land titles, and we're going to learn some things about land. Here's a court case. This is actually not a court case. This is taken from 73, Book 73, Corpus Juris Secundum, Section 13, page 181. Quote, "The right to own and manage property is a natural, unalienable right," unquote. And then another quote, "Perfect ownership is the right to use and dispose of one's own property in the most unlimited manner, and nothing prevents an owner from dismembering his property and from disposing of each separate dismemberment as he pleases," unquote. And that's taken from Amerada Petroleum Corporation versus Reese. That's 196 Southern Reports, page 558, and it's also found at 195 Louisiana Reports, page 350. And so, and what they're saying is that if you own the land, then you have real ownership. You are the king on that land. You have perfect ownership. And if you have some county criminal, basically, coming to you demanding money every year in the form of property taxes, then you don't own it. Okay, and that's what you have to understand is you don't own it. You have some other county crook or some city crook coming to you and telling you you can't do this and you can't do that and you can't subdivide your land and you can't have garbage on your land or you can't do whatever. Then you don't own it. If you own it, you can do whatever you want on that land, and that's what you have to understand. And so many people think they own it and they really don't. And what happens, first of all, you have to understand that when you pay for land, all there is circulating around for money these days is Federal Reserve notes or Bank of Canada notes or Bank of England notes or bank notes, wherever you're at, and they're all nothing more than IOUs. None of them have a promise to pay on them, which is what is required for a promissory note. They all are just nothing more than an IOU. And now think about that. If I get an IOU, if I give someone one of these IOUs, a Federal Reserve note, which is nothing more than an IOU, if I give someone a Federal Reserve note as payment for something, then what I'm essentially saying is some guy promised to pay me, and when he pays me, I'll pay you. Okay? And so what's essentially happening is that land is not paid for. And it won't be paid for until somebody pays lawful money. And Federal Reserve notes are not money. I can show you court citations from secretaries of the Treasury that say that it's not money. So anyways, and we're going to talk about that in this presentation today. So the point is that they are nothing more than an IOU. So what happens is that it creates a trust. Okay, this is a type of a trust called a usufruct. You look it up in a law dictionary, USUFRUCT. Okay, it's a usufruct, and you have the right to use the land, but you don't own it, and that's why they're charging you a yearly rent. That's why they set up in the county records. They went and criminally convert your name into a Sesticate trust. Okay, that name with all block capital letters, that's a Sesticate trust. Okay, I can show you court cases that say that a taxpayer is a Sesticate trust, and that goes back to the Vatican is where that goes to. So the point is that until you actually own that land, then they're going to be running around telling you you can't do this and you can't do that and all the rest of it. You know, I had in Utah, I had some land, and I wanted to put in an underground sprinkler system, and I was down at the sprinkler store buying a bunch of parts and stuff like that, and this guy that was running the sprinkler store, he was sitting there telling me that I have to do this and I have to do that, and I started getting on his case, and I told him that you're violating my rights under the color of law right now because I don't have to do anything, and he shut up. He didn't say nothing else. He just sold me what I wanted, and then that was the end of it. He was sitting there trying to sell me all sorts of junk, and according to their codes, yes, I have to buy all these junk, but I don't have to pay any attention to those codes because they're all color of law. And again, do you know who you are? This is some definitions taken from Black's Law Dictionary, 6th edition. An absolute estate is a common law classification. An absolute state is a full and complete estate or an estate in lands not subject to be defeated on any condition. And then allodial means free, not holden of any lord or superior, owned without obligation of vassalage or fealty, the opposite of feudal. Okay, and what you're seeing nowadays is feudal. It's all feudal. You don't own, very few people in this country own land. And what happens when you go and use Federal Reserve notes to pay for the land? You're basically giving it back to the government, and now they can charge you an annual rent. And that's exactly what's happening. And so it's to the point now that the courts automatically presume that Federal Reserve notes were used, and so I put it, when I do it, I put it on the face of the deed that I converted upon receipt of 21 Silver Eagle coins, pure silver with a face value of $1 each for a total of $21 in lawful money. I hereby grant and convey to, me, okay, usually it's from a fictitious entity, a trust or something like that, grants it to me, this land. And that changes everything, okay? And plus I bring forward all the rights and privileges of the original land tap. And so that changes everything. And I've got several pieces of land now that they don't want to talk to me about, and I kind of like it that way. Right now I bought some land in Navajo County, Arizona, and I'm in a little battle with the county assessor. But I think I'm going to get them in jail over this, because I think I've built a pretty good foundation, and when I send this stuff to the Attorney General, I'll bet you that if they're not in jail, there's going to be someone acting in their place. They'll be out of there. Anyways, allodium, under Black's Law Dictionary, 6th edition, allodium means land held absolutely in one's own right and not of any lord or superior, land not subject to feudal duties or burdens, an estate held by absolute ownership without recognizing any superior to whom any duty is due on account thereof, unquote. Well, think about it. That's what they're saying is allodium. Well, if you have land that you have to pay some duty to, like as in property taxes, then they're saying right here in this definition that that's feudal. And so you have feudal ownership in the land, and you don't own it. You have an interest in it. That's why they call it real estate. Matter of fact, we're going to get to that here in a second. Allodium, this is Bouvier's Law Dictionary, 1856 edition, quote, allodium estate signifies an absolute estate of inheritance and contradicts distinction to a feud. Okay, so, I mean, it's either allodium or it's a feud. There's nothing in between. If you register your land, you're essentially giving them the land back, but you can record your land if you choose, and that is not a gift. And what we need to do is we need to train our government bureaucrats. Now, in the U.S., it's actually they're pretty well trained, and especially in a lot of counties, like in Pinal County in Arizona, they're very well trained there. Some counties, they're not as trained as other counties, and some of them are just flat-out criminals. They'll tell you that you got to take it to the county attorney and let him approve it. Well, that's perjury of oath is what that is. And so I would just say, oh, yes, and what's your name here? And for the criminal complaint that I'm going to file with the Attorney General's office. And because I'm not giving it to the county attorney, and you're going to file it right now. Matter of fact, I've got court cases that say that once you give it to them, it's filed. It doesn't matter whether they stamp it or what they do with it. At that point, it's filed. And that's why I don't even go in there. I serve it on them by registered mail, and I have proof of service, and so it's filed. I don't care what they do with it at that point. It's filed. And I'll go for the jugular. You know, I don't pussyfoot around, quite frankly. I get sick and tired of these bureaucrats that purchase their oath at the drop of a hat. Anyways, here's another definition from Bouvier's Law Dictionary, 1856 edition. Real property, that which consists of land and all the rights and profits arising from and annexed to the land of a permanent and movable nature. In order to make one's interest in land real estate, it must be an interest not less than for the party's life, because a term of years, even for 1,000 years, perpetually renewable is a mere personal estate, unquote. And so the point is that they call it real estate today, okay? They call it real estate all over the place, and real estate is not real property, okay? That's the important thing to say. Real estate is not real property, and there's a difference, and that's what this Bouvier's Law Dictionary 1856 edition is saying, okay? In order to make one's interest in land real estate, it must be an interest not less than for the party's life, okay? So you can have an estate in land, a real estate, but then it's not real property. Real property is when you own it. You have absolute ownership. A real estate is something you have an interest in, like your father's estate, as you have an interest in your father's estate. And so you have to understand that there's a difference, okay? An estate is something you do not own, but you have an interest in, like your father's estate. And here's some definitions from Bouvier's Law Dictionary, 1856 edition, and we'll talk about this. Is going to go on for several slides here, quite frankly. We're going through a PowerPoint presentation that I use at my private information shares. Anyways, it starts off title estates. Okay, a title is defined by Lord Coke to be the means whereby the owner of lands hath the just possession of his property, and that's found at Littleton, Coke's Littleton, on page 345, and that's also found at Book 2 of Blackstone's Commentaries, page 195, and it's also Book 1, Ohio Reports, page 349, and this is the definition of title to lands only, okay? So, and then we're going to go through several definitions here. Definition number 3, it says a title to land is either good, marketable, doubtful, or bad. Okay, so there's only 4 kinds of title. It's good title, marketable title, doubtful title, or bad title. And then definition 5 says a marketable title is one which a court of equity considers to be so clear that it will enforce its acceptance by a purchaser, unquote. Now, you have to understand that a court of equity, now, there's 2 kinds of title in land, okay? There's legal title and there's equitable title. Legal title is when you buy the land, okay? But say, for example, you have a mortgage on it. Well, so you don't have equitable title then. The bank has equitable title. And then again, when we go through the presentation on martial law, we learn that everything's under martial law, and under martial law, there's no common law. And the court of equity is supposed to follow common law, but when there's no common law, then a court of equity can do anything they want. And so that's essentially what you see in the courts nowadays, because the courts will actually tell you that I can do anything I want in this court, and they can. And the reason is because there's no common law. Under martial law, there's no common law. That's why you go into their courts and you'll see a gold fringed flag. It's a military court. That's exactly what that is. And so you have to understand what's going on and what's happening, and they're playing some little tricks under law merchant to get you to be a surety or accommodation party for their fictitious entity. That's exactly what they're doing. And so once you understand what's going on and how it's happening, it's easily defeated. But you have to understand, and you have to bring up the right issues, or else they'll just railroad you, and you'll be screwed, basically. The bottom line is that a marketable title is one in which a court of equity considers to be so clear it will enforce its acceptance by a purchaser. And now, marketable title is what the banks usually want in order to provide funding for a loan. Okay, so that's where this marketable title word comes in. The doctrine of marketable titles is purely equitable and of modern origin. This is definition number 7. The doctrine of marketable titles is purely equitable and of modern origin. At law, every title not bad is marketable. And that's actually, there's several court citations that are mentioned here. Pennsylvania Law Journal, Book 2 of Pennsylvania Law Journal, page 17. There's also 6 Taunt R 263, 5 Taunt R 625, SC 1 Marsh, and then so I'm not sure which those are kind of citations I haven't heard before. I suspect that they could be found in the English reports in England, but I don't know. But anyways, that's where this stuff is. It's all taken from Bouvier's Law Dictionary, 1856 edition. Okay, so then definition number 9 says, at common law, doubtful titles are unknown. There, every title must be either good or bad. Okay, there's no marketable title and there's no doubtful title. At common law, it's either good title or bad title. Either you have the title to the land or you don't. And that's actually some court citations too. Actually, 2 Pennsylvania Law Journal, page 17. But all of this, again, is taken from Bouvier's Law Dictionary, 1856 edition. Titles of state, definition number 10. A bad title is one which conveys no property to a purchaser of an estate, and yeah, that's what I would say. I don't know how many people have ever heard of the Brooklyn Bridge getting sold, but the Brooklyn Bridge has been sold on numerous occasions. But the interesting thing is that it's the state of New York owns the Brooklyn Bridge, and so when it gets sold, obviously the state of New York hasn't sold it, so then that would be bad title, wouldn't it? Anyways, title to real estate is acquired by two methods, namely by descent and by purchase. Okay, in other words, you get title to real estate by two ways. Okay, you buy it or it's passed on in your family. Now, I know people in Arizona who have passed on the title in their land in their family for generations, and they've never paid property taxes. The county assessor doesn't have anything to say to them. And they don't pay property taxes. And so what generally happens when a father passes on his land to his son, he gives his son a quitclaim deed, and then his son possesses the land for 7 years, and after 7 years, it's a moot discussion anyways. And if the father owns all the land, then there's nobody going to dispute what's happened anyways. But after 7 years, it wouldn't do any good to dispute it because the son has had it for 7 years, and that's squatters' rights. So anyways, and now we're going to talk about deeds. Remember I said just a minute ago, a quitclaim deed? Well, that is a type of a deed that you see. There's several different kinds of deeds that we're going to talk about here today. There's a general warranty deed, a special warranty deed, a sheriff's deed, a judicial deed, a quitclaim deed, and a land patent. A general warranty deed is where the seller wants the title to be free and clear of all liens and encumbrances. It's generally what is received in order to get a mortgage before the bank will authorize the mortgage, and it's also considered marketable title. A special warranty deed is a deed where the seller will warrant the land to be free and clear of all liens and encumbrances with some reservations. And a special warranty deed is usually used when the land has been the subject of a foreclosure or tax sale, and a special warranty deed is considered marketable title. And the reason there's a reservation is because there's clouds, okay, on the title. If the land is subject of a foreclosure or tax sale, okay, a foreclosure or tax sale is color of law, okay? All of that is color of law. And so if the guy that owns the land knows the law, then and you buy some land under a foreclosure or tax sale, you may not be buying anything. And so you have to understand that. That's the reason I don't buy land on a foreclosure or tax sale, because that's, you're taking a risk. You might not be getting anything, because if the owner of that land that got his land stolen essentially by the taxing authorities or the bankster thieves, if the owner of that land knows the law, then they didn't sell anything. He still owns that land, and the courts will rule in his favor if he brings up the right issues. Anyways, a sheriff's deed is another deed. It's when the sheriff sells a piece of real property, and could be from a foreclosure tax sale or something like that, and it's considered marketable title. A judicial deed is when a judge orders real property sold, and it's also considered marketable title. A quitclaim deed essentially says that the seller transfers his interest in the property. Like, for example, Brooklyn Bridge, for example, anytime it's been sold, it's always been sold by a quitclaim deed. Anybody that knows anything about real estate or real property would never, ever give a general warranty deed, because now that's a fraud, okay? But he could get away with giving a quitclaim deed, and basically the quitclaim deed says, I sell my interest in this bridge. I may not have an interest, but what interest I have, I sell. That's what a quitclaim deed says. And so a quitclaim deed, property sold because of a tax sale or a transfer, it can be transferred by a quitclaim deed, because think about it. And I've seen anytime tax sales are done, there's counties in Texas that you can do a search on the internet and buy land all day long under from tax sales, and it's always done by quitclaim deed. And essentially what the county is saying is, we sell our interest in this property, and the burden's on you to prove that you have ownership in that property. It's not burdens on them, okay? They follow their color of law. The burden's on you, the buyer, to prove that you bought something. And that's the way it's buyer caveat emptor, buyer beware. A quitclaim deed is a deed of conveyance operating by way of release that is intended to pass any title, interest, or claim which the grantor may have in the premises, unquote. And that's taken from Black's Law Dictionary, 6th edition. So you got to understand these kinds of titles, because if somebody is giving you a quitclaim deed, it may transfer complete ownership of that land, okay? But it also may transfer nothing. And so you got to know what's going on, and because you may get nothing, you may have ownership, and you may get nothing. Color, okay? This is all color of title, okay? Color. So we're talking about color of title right now. Color means an appearance, a semblance, a simulacrum, as distinguished from that which is real, a prima facie or apparent right, hence a deceptive appearance, a plausible assumed exterior, concealing a lack of reality, a disguise, or a pretext. And that's taken from Black's Law Dictionary, 5th edition, on page 240. Colorable, okay? Colorable means that which is in appearance only and not in reality what it purports to be, hence counterfeit, feigned, having the appearance of truth. And that's a court case called Wendell v. Flynn, 196 Oregon, page 654, and it's also found at page book 251, Pacific Report, 2nd edition, page 136. Color of law means the appearance or semblance without the substance of legal right. Misuse of power possessed by virtue of state law and made possible only because wrongdoer is clothed with authority of state is action taken under color of law. And that's a court case, Atkins versus Lanning, U.S. District Court for Oklahoma, and that's found at Book 415, Federal Supplements, page 186. Quote, these deeds includes the one as follows: warranty deed, quitclaim deed, sheriff's deed, trustee's deed, judicial deed, tax deed, will, or any other instrument which purportedly conveys the title. Each of these documents state that it conveys the ownership to the land. Each of these, however, is actually a color of title, unquote. And that's taken from G. Thompson, titled Real Property, Preparation and Examination of Abstracts, Chapter 3, Section 73, page 93, and that 1919. So all of these kinds of titles that we talked about are all color of title, okay? So they're a fraud. And if you know the law, you can defeat it. Matter of fact, when I was Speaker of the House of Representatives, we were actually talking about possibly selling, theoretically, everybody has color of title. Nobody has real title. Actually, I won't say nobody does, but very few people do. And so you could actually sell the land out from somebody, okay, because they don't have a title. And you could actually sell the land out from underneath someone. And that's what I was talking to some First Nations chiefs about doing, or I'd like to do, is because the First Nations chiefs are the ones that really have title to the land. And so I was going to get them to grant me the land, and I called it boiling a frog, So you start off with some land that they don't care about out in the middle of nowhere, and so I get them to grant me that land, and I serve them with notice, and I tell them I've got this First Nations land grant, and I'm taking possession of my land, some BLM land or Crown land in Canada, and on this date I'm taking possession of my land. And then you go there and you put up signs and you start showing ownership and possession, and let them get used to that idea. And tell them also, oh, by the way, if you want to talk about this in court, I'll be more than happy to talk about it in court. But I don't think they want to, because there's all sorts of court cases that say that, for example, there's court cases that say that they have to settle the First Nations land claims. Well, think about it. If the courts are telling the government that they have to settle the First Nations land claims, they're essentially saying that they stole the land from them. And so they're saying that these land claims are valid. And so if they sell me some land, then they have every right to sell me some land. And so that's why I say I don't think they want to talk about it in court. So then what we do is what we would do is we would get the First Nations to grant me some land that's not necessarily remote, but not that important, kind of closer in, but not that close. And I get them used to that idea, and then get them to sell me the land underneath the Parliament buildings, and send them a bill for property taxes, and proceed that way. I guarantee you, They wouldn't like it, but there'd be nothing they can do because they don't own it. Quote, when we say a person has a color of title, whatever may be the meaning of the phrase, we express the idea at least that act has been previously done by which some title, good or bad, to a parcel of land of definite extent has been conveyed to him, unquote. And that's St. Louis versus Gorman, 29 Missouri Reports, page 593, 1860. Quote, there the complainant seems to have relied upon the tax deed as conveying to him the fee, and to sustain such a bill, it was incumbent upon him to show that all the requirements of the law had been complied with, unquote. And that's Halls versus Bunton, 47 Illinois Reports, page 396, 1865. Now, I was talking about this a minute ago, okay? Because what happened is, and I'll read this, okay, again. It says, there the complainant seems to have relied upon the tax deed as conveying to him the fee, okay? So in other words, he got a tax deed to this land, and the owner knew the law and said, you don't own this land, this is my land. And the owner knew the law, and so this guy took it into court, and the court is saying that he relied upon the tax deed as conveying to you the title, and the burden's on you to show that all the law requirements of the law have been complied with. And he hadn't. And so the court is saying, essentially, it looks to me like they're saying that you just bought nothing by buying that tax deed. And so that's, again, I can't tell you enough, these tax deeds, these quit claim deeds, that's all color of law. These people were nothing but thieves. And you have to understand that's exactly what's going on. Quote, authorities hold that to render a title marketable, it is not only necessary that it be free from reasonable doubt. In other words, that a purchaser is not entitled to demand a title absolutely free from every possible suspicion, unquote. And that's Clymings versus Dolan, 52 Washington Reports, page 496, 1909. And they're talking about marketable title, and they're saying that it doesn't have to be absolutely free from every possible suspicion. It's only free from reasonable doubt. So what they do is they do a title search, back, like the last maybe 2 or 3 property transactions, and that's it. Quote, a patent to land issued by the United States under the authority of law is the highest evidence of title, something upon which its holder can rely for peace and security in his possession. It is conclusive evidence of title against the United States and all the world, unquote. And that's Book 2, The American Law of Mining, Section 1.29 at page 357. And that's quoted in a court case called Nichols versus Rice AV. That's a South Dakota case, 1985, found at Book 610, Federal Supplements, page 1245. Quote, nothing but a patent passes a perfect and consummate title, unquote. And that's Wilcox versus Jackson, 38 U.S. 498, 1839, that's U.S. Supreme Court. Quote, a patent issued by the government of the United States is legal and conclusive evidence of title to the land described therein. No equitable interest, however strong, to land described in such a patent can prevail at law against the patent, unquote. And that's Land Patents, Opinions of the United States Attorney General's Office, September 1869. And so I think that speaks all by itself. Okay, keep moving here. A patent is the highest evidence of title and is conclusive evidence against the government and all claiming on junior patents or titles until it is set aside or annulled by some judicial tribunal, unquote. Notice they use the word tribunal, eh? They're all tribunals. Military court. Stone versus United States, that's found at 2 Wallace, 765, 1865. And that's U.S. Supreme Court. Quote, issuance of a government patent granting title to land is the most accredited type of conveyance known to our law, unquote. And that's United States versus Creek Nation, 295 U.S. 103, in 1935. And it's also found at United States versus Cherokee Nation, 474 Federal Report, 2nd edition, page 628, and that's 1973. Quote, A patent is intended to quiet Title II and secure the enjoyment of the land for the patentees and their successors. Thus, as a quitclaim deed, a land patent conveys whatever interest the government has in the soil and the land, unquote. And that's Key Family Limited Partnership versus State Board of Tax Commissioners, and that's found at cause number 02T10-9906-TA-145, and that's September 2001. Quote, as we have noted in connection with a patent by the United States, the patent's effect is the same as though the United States had executed a quitclaim deed, unquote. And that's City of Anchorage versus Nesbitt, 530 Pacific Report, 2nd edition, page 1324, Alaska, 1975, and they're quoting Wilson Cypress Company versus Del Pozo Marcos, 236 U.S. 635. That's U.S. Supreme Court, 1915. Now, the interesting thing here is they're saying, as we've noted in connection with the patent by the United States, the patent as a fact is the same as though the United States has executed a quitclaim deed. And why do you think that that is the case? Well, the reason that is the case is because the United States didn't own the land to sell it in the first place. That's exactly what it is. They didn't own the land. The First Nations never gave them the land. And so, therefore, they didn't own it. And they essentially stole it from the First Nations. That's exactly what's happening. Quote, a patent operates as a deed of the government. As a deed, its operation is that of a quitclaim. It passes only the title the government has on the date of the patent. And that's, unquote, and that's found at 63A, Book 63A, American Jurisprudence, 2nd edition, Public Lands, section 77 at page 574, 1984, and that's quoted in a court case, North Star Terminal and Stevedore versus Alaska Railroad Corporation, 1993, and that's found at 857 Pacific Report, 2nd edition, page 335. So, again, it's a quitclaim deed. A patent, a land patent, is the highest and best title, and yet it's a quitclaim deed. And that's why a First Nations title is the best. And that's why I'd like to get some jure First Nations chiefs to work with me on that if they're interested, and stir that pot. Quote, a patent of the United States as a deed, its operation is that of a quitclaim, or rather of a conveyance of such interest the United States possessed in the land, unquote. And that's Beard versus Feedery, 70 U.S. 478, that's U.S. Supreme Court, 1865. A land patent is the highest and best title, but at the same time, it is a quitclaim deed. It's a color of title. If a land patent is a colorable title, then what would be the true legal title? Quote, there is nothing here requiring a deed to establish a color of title, and under the former decisions of this court, color of title may exist without a deed, unquote. And that's Baldwin versus Ratcliffe, 125 Illinois, page 376, 1888. And what they're talking about there is squatters' rights. If you live on the land for 7 years, then you're the owner, okay? And that's really what it comes down to. That's why, with the old homesteading, okay, I don't know how many people remember that, but when they used to do homesteads, and they still do homesteads in some areas, but when they did homesteads, you have to live on the land for 7 years. After 7 years, you own it anyways, and they usually give you a land patent at that point, but they really don't have to, because once you live on it for 7 years, you get squatters' rights. The courts have ruled that the government has to settle the land claims of the original people. They are essentially saying that the government stole their land, and then I've got some Crown patents here, and they're in a box. The ones that I've got are in a box. I've also got a U.S. land patent. And what it says, this is one that's on some land that I bought actually in northern Arizona, and I think it's actually this land that I'm fighting with in Navajo County right now. But anyways, this is one of the railroad land grants, and I don't know how many people know this, but when the railroads were put in, the government granted to the railroad companies 10 miles of land on each side of the railroad, as far as the railroad went. And that was, the purpose of that was so that the railroad companies would sell that land and make the money back to pay for putting the railroad in. So actually, that probably wasn't a bad idea, except they stole it from the First Nations. Anyways, this is the only text that's on this patent, okay, other than the legal description of the land, okay? And it's like, it's about 6 or 7 pages, and it says section this, section, section, township, and range, and it lists a bunch of sections, so I mean, it's huge tracts of land. That's why I say it's 10 miles. Remember, a section is 1 square mile, and so it's 10 miles on each side of where the railroad went. Anyways, it says here, and granted, and by these presents does give and grant unto the said Santa Fe Pacific Railroad Company, successor in interest to the Atlantic and Pacific Railroad Company, and to its successors and assigns, the tracts of land listed as aforesaid and described to the foregoing, to have and hold to said tracts, with the appurtenances thereof unto the said Santa Fe Pacific Railroad Company, successor as aforesaid, and to its successors and assigns forever. And that's all it says. That's all it says. It doesn't say a word about property taxes. It doesn't say a word about easements. It doesn't say a word about zoning rules and regulations. It doesn't say a word about anything. Okay, now this is absolute title, because once you have a patent, you have absolute title to the land. There's no limitations. Now, on some of the more recent titles I've seen, like on this land that I bought in Arizona that the bankster thieves stole from me, there was actually mineral rights were reserved, and some land that I have in Texas actually has mineral rights reserved. But that's it. There's nothing else. It doesn't say anything else in there about property taxes or land patents, I should say, or easements or anything. It says nothing on there about any of this stuff. And then at the very end of this patent, it says on the very last page, it says, in testimony whereof I, Woodrow Wilson, President of the United States of America, have caused these letters to be made patent, and the seal of the General Land Office to be affixed, hereunto affixed, given under my hand in the city of Washington, the 2nd day of December, in the year of our Lord, 1915, and the independence of the United States, the 140th, year, by President Woodrow Wilson, by, looks like M.P. DeLeroy, Secretary, and looks like L. something Lamar, Registrar of the General Land Office. And that's it. That's all it says. And so the land patents are extremely powerful, and you have to understand that it's very powerful. Okay, a land patent is absolute title to land. Recent land patents are inside a box. That tells me, like this Crown patent that I have, it's inside a box. That tells me because a box in international law takes it off the page. And so that means that there is no land patent. If you want to sue somebody over this land patent, then that's what they'll say is there's no land patent here, because there's nothing on that page. It's inside a box. That tells me they know they don't have any authority. That means that, it's all just a big charade. It says on the land, it says the land is granted to John Smith, his heirs, and or assigns forever. All Crown patents I've seen reserve something, mineral rights, trees, water rights, something. All land patents say nothing about property taxes, say nothing about easements, say nothing about eminent domain, say nothing about zoning rules and regulations. Now, I don't know how many times, and how many of you have seen land that goes along in a straight line until it gets to some guy's land, and then it'll go around that land, and then it'll keep going in a straight line. And I've seen that on numerous occasions, and the reason is because that guy still had the land patent. He still had absolute title to his land. If you paid for your land with Federal Reserve notes, then you don't own your land, and they're charging you yearly rent, and they can take it from you. That's when they exercise eminent domain, and that's because you don't own your land. They can take it from you, and they do. They do it all the time. And that's what you have to understand. If you want to really own your land, then there's a couple things you have to do. Is you have to defeat that usufruct. You have to actually pay for it. and you have to bring forward all the rights and privileges of the land patent. Sometimes they reserve mineral rights on these land patents, like the one I've got from Texas reserves mineral rights, but other than mineral rights, I haven't seen them reserve anything else. A usufruct, this is taken from Bouvier's Law Dictionary, 1856 edition, page 1191. Quote, usufruct, civil law, the right of enjoying a thing, the property of which is vested in another, and to draw from the same all the profit, utility, and advantage which it may produce, provided it be without altering the substance of the thing, unquote. And so that's exactly what you have if you paid IOUs for your land, because it's not paid for, so you have a usufruct, and a usufruct is a type of trust. Bank of Canada notes or Federal Reserve notes or Bank of England notes or IOUs. Okay, and here's a court case called Juilliard versus Greenman, found at 110 U.S. 432, U.S. Supreme Court. Quote, the forced loans of 1862 and 1863 in the form of legal tender notes were vital forces in the struggle for the national supremacy. They formed a part of the public debt of the United States, the validity of which is solemnly established by the 14th Amendment of the Constitution, unquote. So what they're talking about there is U.S. Treasury notes that were circulated to finance the Civil War. And so they had all it said on them is this note is legal tender. And that's exactly what the notes say now. They're forced loans, and they have no intention of ever paying it back because it doesn't say on it that it's redeemable, okay? And so therefore, they have no intention of ever paying it back. It's just flat out theft is what it is. And but they're IOUs. That's all they are, is IOUs. And that's what you have to understand. And we talk about that when we go through the presentation on money. They're nothing but IOUs. When you buy land, paper land with a banknote or commercial paper, which is what a Federal Reserve note is, or a Bank of England note, it's not paid for. Therefore, a trust or a usufruct is created. That's exactly what happens. It's called a constructive trust. And that's why you don't own it. That's why the government can exercise eminent domain, and the government essentially, by paying for the land with their commercial paper, you essentially give it back to them. It's exactly what happens. Have you ever, and I talked about this before, have you ever seen a road that goes along in a straight line, and when it comes to some guy's land, it turns and goes around the other side of the land? That's because all those other landowners didn't really own the land, except the guys whose land they went around. There's Spanish land grants in Arizona that you go in any county recorders or county planning or a website, or not their website, you go in their office, and you'll see where these they have a big map on the wall that shows the all of Arizona, and they'll show these huge tracts of land that are these Spanish land grants. And the Spanish land grants were granted to when Arizona was part of Mexico. This land was granted by Spain. Okay, actually it was part of Spain. Spain owned it. It was part of Mexico, but Spain was sovereign over it. So, and Spain, the king gave huge tracts of land to royal families in Spain, and they still own that land to this day. And I guarantee you, they're not paying any property taxes on it either. And that's it. I know people in Arizona who've had their family for generations, and they do not pay property taxes and never have. I've heard of people in Canada who, when they inquire about their land with land titles in Canada, and the response is that land titles has no jurisdiction. Okay, and so then that's telling me that they have absolute title to that land. Evidence of your usufruct. Okay, they call it real estate. You pay a yearly rent in the form of property taxes. They can take it away from you, eminent domain. If they take it away from you, then you do not own it. If the land has easements, utilities, roads, etc., if the land is subject to zoning rules and regulations, there's a whole bunch of things that go on. And what do? If you don't pay those property taxes, they do what's called a unlawful detainer action. And that is an action to kick out the renters. And furthermore, when you buy the land, they ask you, how do you want a vest title? Do you want it as joint tenants or tenants in common? Okay? That's invariably, they'll give you those two choices, the operative word being tenants. You're not an owner, you're a renter. If you pay for the land with an IOU, it creates a usufruct. And the way you defeat the usufruct is you have to pay for it with gold or silver coin, and you have to say it on the deed. You have to show it on the deed. How do you have true loyalty to land? You bring forward all the rights and privileges of the original land patent. You pay for your land with gold or silver coin. At common law, all numbers are spelled out. In other words, it's FIVE. It's not the Arabic numeral 5, okay? That's in the matrix. You have to, again, if you look in these land patents, it's always all spelled out. Legal description should be in metes and bounds. You can say, also known as Lot 1 of the Rancho subdivision, to eliminate any potential confusion, but it should be in metes and bounds, although this land that I got in Arizona, I'm using Lot 1 of some, I think it's Lot 105 of some subdivision, but I don't think that, again, it depends on how much you want to push it or they want to push it. I guess we'll see. A patent from the original people would trump any other patent. It would trump anything else. There's a guy that I heard about in BC, and I haven't been able to contact this guy. I have no idea who he is, but there's a guy I heard about in BC that the bankster thieves were trying to steal his house, and so he proved in court that the Crown was only granted about 400 acres by the First Nations, and so all the rest of the land in BC, the Crown didn't grant, and so therefore the Crown had no right to grant, and so therefore he had essentially a First Nations title, and the court dismissed the foreclosure action that the bank had brought, and so that says volumes right there. Because almost everything that's done these days is done with commercial paper. The courts presume that commercial paper was used. You can defeat their presumption by putting on the land transfer document the type of payment that was received, gold or silver coin. Bill of exchange, for example, I always call it a bill of exchange, or at least I do on my recent ones. Upon receipt of 20 each 1 troy ounce pieces of pure silver, each I do hereby grant and exchange to John Henry, House of Smith, this land together with all the rights and privileges, the original land patent number, 123456, a true copy of which is attached here too, and all of which is incorporated herein by reference in its entirety. And that's all it has to say. It doesn't have to be real wordy. You've got to put in the legal description of the land, whatever that legal description is that you were provided with. But that's it. It's not terribly complicated. But, you know, you just have to think about it. Okay, moving on. When you get true loyal title, you do not tell them that you purchased your land, okay? If you purchased or bought your land, a commercial transaction took place. You tell them that you converted some silver or gold to land. Conversion is common law, and I've seen court cases that talked about it that way. This is taken from the Indian Act of Canada, Section 2, Subsection 1. Quote, in this act, surrendered lands means a reserve or part of a reserve or any interest therein, the legal title to which remains vested in Her Majesty. It has been released or surrendered by the band for whose use and benefit it was set apart, unquote. Man, what a scam that they go and twist things around. They're essentially saying that the First Nations gave them the land and they're giving it back to them to use, but they're keeping ownership. What a bunch of thieves. You know, I mean, I can't believe that, you know, but again, they're thieves. Quote, subject to any orders or regulations made under this act and until otherwise provided by or pursuant to any other act of the Parliament of Canada, subsection, subject as aforesaid, the court shall exercise its prize jurisdiction in respect of the like persons, matters, and things. And it basically goes through and talks about, and this is taken from the Prize Act of Canada, Section 5, Subsection 2. And that's exactly what they're doing, is they're a bunch of pirates operating on the high seas of commerce trying to get some prize. And when they steal your land from you or your house or your car, that's what it is prize. Some jurisdictions have a land transfer tax or an affidavit of property value. If you pay the tax or provide the affidavit in your property, the tax rolls. Think about it. That's perfect. Matter of fact, anytime in Arizona is a good example. I don't give them an affidavit of property value, and that's actually worked pretty good for me, except in this last one. And that's why I'm wondering what's going on. But again, I've got a criminal complaint. I'm gonna probably get them put in jail because I didn't give them an affidavit of property value. Anyways, because what you do is you serve them your document by registered mail, and you don't. And what they'll do is they'll return it to you saying that it's not recorded, but it's in a special file until you fill out this affidavit of property value or pay this land transfer tax. That's perfect. Don't ever pay it. They put it in the taxpayers file. Some counties require it to be a land title document before you can record it. That's easy. In the top right-hand corner of the document, you just put land title document, section 26, range 3 north, township 3 north, range 36 west, west of the 4th meridian. Okay, and I mean, whatever your particular description is for your land, and it doesn't have to be anything smaller, you just a section. Even if all you've got is a city lot, you just break it down to the section. That's all you need. You just put that up in the top right-hand corner of your document now, and it's called land title document. You can show the clerk that, hey, it's a land title document, so go ahead and record it. And I don't care if it's an affidavit. I don't care what it is. That's exactly what you do. I did that in Utah, and Utah requires that. And I got all sorts of documents recorded in Utah by doing that. Anyway, so it ought to work anywhere. Quote, an instrument is deemed in law filed at the time it is delivered to the clerk, regardless of whether the instrument is file marked, unquote. And that's Biffle versus Morton Rubber Industry, Inc., 785 Southwest Report, 2nd edition, page 143. And that's Texas, 1990. Okay, so that's why I serve it on them by registered mail. I don't care what they do with it. I got proof they got it, and it's filed. That's all I need to know. If they want to send it back, I don't care. And that's perfect, because now they told me that it's in that special file. That's the non-taxpayers file, and I don't have to worry about it anymore. I will never, ever send them that affidavit of property value or anything else. Quote, the King of England held ownership of land under a different title and with far greater powers than any of his subjects. Though the people of England held fee simple titles to their land, the king actually owned all the land in England through his allodial title. And though all the land was in the feudal system, none of the fee simple titles were of equal weight and dignity of the king's title. The land always remained allodial in favor of the king, unquote. That's how they get eminent domain. And remember, it says any of his subjects up at the top. And that's found at Gilsbert of Mons, Chanique, chapter 43, page 75. And that's where that's found. That sounds like a book. Anyways, so they're talking fee simple. Okay, that's a feudal title. Okay, fee simple. They're talking taxes. That's taxes. It says here, though all the land was in the feudal system, none of the fee simple titles were of equal weight and dignity of the king's title. Right. So it's all talking about feudal here. So fee simple is feudal. And that's another thing that they tell you, oh, you got land in fee simple? Well, that's a feudal title. So anyways, also because we the people are sovereign in America, then we have absolute title. And so again, but we have to assert it. So again, the burden's on you to bring up the issue. It's like somebody comes walking up to you on the street and says, you owe me $50. If you give them $50, well, then you must have owed it to them. And if you say, start talking to them about the terms of the contract, like, for example, yeah, but I gave you $5 yesterday, then you're debating the terms of the contract, and you've given them the contract. And so that's what the IRS does, if you think about it. And so if the IRS comes up to you and says, you owe us $50, and you say, yeah, but I filed last year and I didn't owe anything, well, you just gave them the contract. That's exactly what you did. And so now you're going to debate the terms of the contract, and you're dealing with thieves. So they can make up any old rules they want, and that's exactly what they do. Okay, that's the end of that one. Let's go on to martial law. we'll learn a little bit about martial law. Everything is under martial law, but martial law is voluntary. You have to understand that it's all voluntary. They have to get your consent. And it's martial law is for subjects, okay? Sovereigns, it doesn't apply to. Again, we'll talk about that. Government is not force, it is not reason, it is not eloquence, it is force. I'm sorry, let's start that over again. Government is not reason, it is not eloquence, it is force. It is a dangerous servant and a terrible master, and that's a quote by George Washington. So you have to understand, they're not your friends. They might be your public servants, but they're certainly not your friends. And that's the important thing to understand. So we're going to talk a little bit about martial law today. Almost all governments are under martial law. Almost all governments are bankrupt, and it's the responsibility of we the people to keep our government under control. And if you think about it, right now the U.S. government is going off in foreign countries and making war on foreign people and doing all sorts of stuff. What would happen if they all of a sudden, like right now, we're pretty powerful and we're able to do a lot of things that they don't have any, they can't really resist. But what would happen if, say, they were able to do some stuff and were able to come back and kick our butts, and they'd be kicking our butts then, and they say the government is to the point that they're winning, right? And the reason that would be happening is because we let our government get out of control. That's exactly what happens. It's our responsibility to keep it under control. And that's what's happening right now. It's running away with itself. This is a quote taken from a revised Code of Washington, Section 1.16.090. Says, Legislative Declaration for Civil Liberties Day of Remembrance. The legislature recognizes that on February 19, 1942, the President of the United States issued Executive Order 9066, which authorized military rule over civilian law and lives, unquote. And so, right there, in the Revised Code of Washington, it says everything's under martial law. We're under martial law. There's three kinds of martial law. There's full martial law proper, and martial law rule. And this is all taken from a U.S. Supreme Court case, Ex parte Milligan, found at 4 Wall, which is 71 U.S., page 2. And it's also found at Book 18, Lawyer's Edition, page 281. Okay, so that's Ex parte Milligan. And this is also found in a case called Diet versus Turner, 439, Pacific Report, 2nd edition, page 266. 1968, and it's also found in the non-ratification of the 14th Amendment by Judge H. Ella of the Utah Supreme Court. Full martial law is a declaration of martial law is issued. Troops are put on the streets. It's used only during wartime. It's used on a foreign country when actually invaded by a foreign power or to put down an armed rebellion. Martial law proper, okay, remember we're talking about three different kinds of martial law. Full martial law proper, and martial law rule. Okay, so martial law proper is the law of the armed forces. It's when a captain tells a private what to do. It's enforced by court-martials. And martial law rule is the law of necessity and emergency. And let me stress that, as necessity and emergency. And that's exactly what's going on now. They're using necessity and emergency as an excuse to impose martial law on us. Allows the domestic use of martial law powers, and it's used during peace times. That's martial law rule. That's exactly what's happening and has been happening since the Civil War. Evidence of martial law rule. Military script is circulated for money. Quote, the action of Congress in the passage of the first Legal Tender Act was placed distinctly upon the ground of the existing imperative need of government, and the Legal Tender Clause was urged and adopted as a war measure. Well, that's martial law. War measures, martial law. And that's Juilliard versus Greenland, 1884, 110 U.S. 421. That's U.S. Supreme Court. Evidence of martial law rule. Military script is a forced loan. We talked about that in the land titles, and we'll talk about it again in the money. Quote, the forced loans of 1862 and 1863 in the form of legal tender notes were vital forces in the struggle for national supremacy. They formed a part of the public debt of the United States. That's Juilliard versus Greenman. Again, that's the same court case, 1884, 110 U.S. 421. Let's see here. Is it not right, somebody's asked the question, is it not right that if people support the government and the government is found guilty of genocide, then the people will be held responsible too? Isn't there a law that states that somewhere? Well, yes and no. I mean, the governments are corporations, and so certainly the government's responsible, and officials in the government, and a good example of that is the Nazi war crime trials. The Nazis, after the Second World War, they put them all on trial for war crimes and crimes against humanity and stuff like that. And one of the things they asked them, they said, under what authority did you do what all you did here? And the Nazis' answer to that was that nobody complained. And most of them suffered death by hanging, and the ones that didn't suffer death by hanging spent the rest of their life in jail. And so as far as the genocide is concerned, I don't think the people, quote, the people would be held responsible, but certainly the government and officials in the government would be held responsible for sure if there's genocide. Matter of fact, that's one of the issues I've been bringing up in my paperwork, is how there's a Roe v. Wade. I'm sure that many people have heard of this Roe v. Wade court case in the U.S. that says that they can do abortions. Well, you know, if you read that case, what it says is the 14th Amendment, or no, it says the unborn are not a person as defined by the 14th Amendment. Well, if the unborn are not a person, see, there's two classes of citizens. Again, we talked about that in the citizenship presentation. If there's two classes of citizens, then there's a citizen subjects and the citizen sovereigns. Well, if they're not a citizen subject, then they're a citizen sovereign. And so what essentially the Supreme Court is saying is that let's commit genocide against the sovereignty. And that's exactly what they're doing. And that's a common law crime too. It's infanticide is a common law crime, and that's to kill an unborn baby. So at any rate, I like to bring that stuff up, and they've actually passed some laws because of it, but it really hasn't made much of a difference. They still go ahead and do the stuff they do. Anyways, why don't we take a break? Kat, can we take a break, and we'll come back in a few minutes. Hello, everybody out there in Radio Land. This is These Changing Times radio station, and you're listening to Do You Know Who You Are? And this is Glenn Winningham, House of Fern, and we're talking about martial law right now, about how everything's under martial law and how you can tell. And I have a website. My website is www.sovereigntyinternational.info. And I also have some groups. I've got a group on These Changing Times radio website under their groups link. You'll find a group called sovereigntyinternational.info there as well. And I've uploaded some documents there that you might find interesting. And I also upload links to the YouTube videos once I get them published to YouTube. Also, I've got a couple private groups, one at Yahoo and one at Google, and they're called Administrating Your Public Servants. And I've got uploaded a lot of documents that I've done, and there's instructions on and procedures on what to do and how to do it. And there's a little home study class that you have to take too before you can ask a lot of questions, because I got to tell you that I've been asked a lot of questions, and I try and answer most of my questions in the presentations, and so I get tired of answering the same questions over and over again, and so that's why I say I have certain requirements that you do a little bit of home study and go through some of the material, and then after you've done that and you start to get your head around what you're doing, then you can ask some questions. And I'll be happy to entertain any questions, and I'm available on those groups anytime. So anyways, we're talking about martial law rule, and we're talking about military script. These legal tender notes are military script. Bank of Canada notes, Bank of England notes, Federal Reserve notes, all of those are military script. You know, there was a guy that I met one time that had been in Korea in the U.S. Army, and he was telling me how they used to circulate military script on the military base, and he told me how they would every 6 months or every year or so they would come out with new script, and so then they would give them a period of time when they can trade in the old script for new script, and so meanwhile all these GIs had gone, you know, downtown into the Korean town, Korean village, and spent their military script. And so then these local Koreans would be standing at the gate, hey, GI, I give you 50 cents on the dollar if you trade my military script in. And of course, if they got caught doing that, then they would get in a whole bunch of trouble. And so it was a mechanism to screw the locals, is what it was. And anyways, but that was military script, and they did that on a military base. And so you have to understand that the whole country is a military base in Canada, England, and how they do that. And we'll talk about it in this presentation. Quote, Congress, claiming its martial law power to declare war, suppress insurrections, and repel invasions, imposed martial law on the United States and never discontinued it. The result was an extension of military and municipal jurisdiction of Congress. But where's the evidence of this? Look at the 13th Amendment, the Civil Rights Acts, the legal tender laws, the 14th Amendment, et cetera, et cetera, unquote. And that's taken from a court case called Diet versus Turner, 439 Pacific Report, 2nd edition, page 266, 1968. And the non-ratification of the 14th Amendment by Judge A.H. Ellett, the Utah Supreme Court. Quote, the 14th Amendment is an extension of the national military powers presently used in a municipal character and enforced by municipal laws stretched far beyond their original limitations and enforced by Article I tribunals, unquote. And that's again taken from Diet versus Turner, the same court case that this other citation was taken from. And we're going to go through and talk about municipal laws. We'll talk about it here. But we'll also talk about it when we're in the commerce section. And I think we've already gone through that, but we'll go through it again. Quote, since March 9, 1933, the United States has been a state of declared national emergency. Gee, that sounds like martial law rule. Quote, Since not March 9, 1933, the United States has been a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways control the lives of all American citizens. A majority of the people of the United States have lived all of their lives under emergency rule. For 40 years, the freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency, unquote. And that's taken from U.S. Senate Report number 93-549, dated November 19, 1973. Do you think anything has changed? Absolutely not. Okay, let's keep moving here. Quote, war is not carried on by arms alone. It is lawful to starve the hostile belligerent, armed or unarmed, so that it leads to a speedier subjection of the enemy, unquote. And that's Article 17 of the Libre Code. Quote, the exercise of martial law jurisdiction in the several states is the usurpation of the common law and subjects the sovereign body to a jurisdiction that has no right to exist within the states. If a citizen acquires the same legal status or artificial character as those protected by the amendment through the operation of some statutory law of Congress, then said citizen may be brought within the venue of the amendment as a statutory juristic person. By this means, citizens' birthrights become of no effect and their rights are reduced to the inferior character of statutory civil rights, mere legislative privileges, unquote. And that's taken again from Diet versus Turner, 439, Pacific Report, 2nd edition, page 266, and the non-ratification of the 14th Amendment by Judge A.H. Ellett, Utah Supreme Court. So let's look at this again a little bit, because it says here, the exercise of the martial law jurisdiction within the several states is the usurpation of the common law, and that's true. If you volunteer into the martial law, then there's no common law for you. Okay, and so and that's why, you know, you'll see these judges in these court cases, especially traffic court cases and stuff like that, and some guy will go in there and start arguing the Constitution, and the judge will say the Constitution doesn't apply in here, and I don't want to hear another word about it, and he'll be 100% correct. And then it goes on to say, if the citizen acquires the same legal status or artificial character as those protected by the amendment through the operation of some statutory law of Congress, well, that's a cesticate trust. And it's voluntary. They get you to volunteer in. And that's exactly what happens. Then said citizen may be brought within the venue of the amendment as a statutory juristic person. That's a cesticate trust. And that's coming from the Vatican. That's exactly where all of this stuff is coming from. And then in the very end it says, and their rights are reduced to the inferior character of statutory civil rights or mere legislative privileges. Did you know that? Civil rights are legislative privileges. They can be taken away whenever they feel like. They mean absolutely nothing. At common law, your rights are undefined. When they define your rights, they're basically taking away all the ones that they're not defining. And again, statutory civil rights are for the juristic persons. Okay, the fictitious entities, the cesticate trusts, only have limited rights. U.S. citizens, in this case, in the U.S. They don't have their slaves, okay, and they only have rights that are granted by Congress, and they don't have any other rights that what's specifically granted, and they don't have access to common law, and we talked about it in the citizenship presentation. I think there was one court case that said that U.S. citizens don't have the right to the custody of their children over the paramount right of the state. And so that means that Child Protective Services can come in and steal your kids. I mean, it just goes on and on. And so, again, do you want to be a sovereign? Are you the king or are you a slave? You know, it's really what it comes down to. Let's keep moving here. A Federal Reserve note is a bank note. A Bank of Canada note is a bank note. A Bank of England note is a bank note. Banknotes are negotiable instruments. Banknotes are commercial paper. Banknotes are a money substitute. Banknotes are script. Banknotes are not money. That's the bottom line. The banknotes are not money, and we'll talk about that when we go through the presentation on money. Evidence of martial law rule. Income taxes collected under military authority. government seizes money without a court order. Government seizes property without a court order. Government seizes bank accounts without a court order. That's all martial law rule going on. Let's see here. Somebody's made a comment. It says, so it is so that the only courts that are known as legal courts can only be military courts due to the fact that the one who calls herself queen, known as Queen Elizabeth, is not in fact the queen. She's not the real queen. She's not what or who she says she is. So is there a fraudulent queen that leads us to believe there is no such thing as a proper court? England has not had a queen for over 300 years. The last queen was Queen Anne. So do we have access to common law? And how do we get access to common law? You basically have access to common law because by not volunteering into their martial law system. That's essentially what it is. And so the way you do that is you give them notice, okay? And that's what my notices are designed to do, is I give them notice and I tell them I'm the king. And you have no more authority over me than a Walmart rent-a-cop. And here's some court cases you might want to look at. And I just go down the list. And so in England, I'd be quoting Magna Carta. And I tell them you have no more authority over me than a Walmart rent-a-cop, and my court is a jury of my peers, and you don't even have authority to convene a jury of my peers, and so you have no authority over me, you just go down the list, and I mean there's just all sorts of things you could bring up, but again, common law is the law of the people, and so you tell them that you're essentially not volunteering in, and that they have no authority over you, and that any evidence of a birth date, for example, make up your own ID that you use, and any evidence of a birthday is hearsay evidence and not admissible as evidence in a court of law. I mean, you just go poke holes in everything they do, and it just puts it in a position that they cannot proceed. That's what it does. Is it puts them in a position that they simply cannot proceed. Quote, as we have said, the federal personal income tax is collected under a military venue within a martial law jurisdiction. Federal Reserve notes are military scripts circulated within a military venue. The problem is that people don't understand how the entire United States is covered by a military venue. Under the Social Security Act that was brought into existence, 10 federal regional areas. These 10 federal regional areas are the same as a military base, unquote. And that's taken from, again, from non-ratification of the 14th Amendment by Utah Supreme Court Judge A.H. Ellett and this Diet versus Turner case. Quote, it is not unconstitutional to circulate military script on a military base, as the base is considered to be a military venue. Remember, I told you about that with a friend of mine was telling me that he had been in Korea and they were circulating military script on there. Okay, that's exactly what Federal Reserve notes are. Quote, let's start over again. Quote, it is not unconstitutional to circulate military script on a military base, as the base is considered to be a military venue. Military script cannot circulate in the several states. To get around this constitutional bar, the Congress, via the Social Security Act, created 10 military venues called federal regional areas, unquote. And I guarantee you, well, I know they've done it in Canada, and matter of fact, I know they've done it in England too, and it's through the use of postal codes. And we'll go into that. It talks about that here. Quote, the problem the Congress realized, while Congress could restructure the government agencies into these federal regional areas, and the people could not be identified to be within this military venue, but by their own consent. The solution was to create another military venue which would trick the people to voluntarily accept recognition that they're within a military venue. Congress solved this problem by creating the zip code. And that's, again, taken from that Diet versus Turner and the non-ratification of the 14th Amendment. And then so somebody's said something here. It says, so if the corporation that calls itself Her Majesty's Customs and Revenue is a lie and military where the tax is concerned, does this mean that they at the airports and seaports are as much of a fraud? Absolutely. But again, they presume, they work on presumption. Everything they do is based on presumption. You've got to take away their presumptions, and you've got to put them in the position that they have to have an oath of office to honor. So it's all color of law again. Remember, it's color of law. If you look into those statutes, you will get a copy of that statute, and it'll, I guarantee you that it was not signed by the Queen. okay, by Elizabeth. She never signed that thing. And all it'll have is the end of the statute, and it'll have her name printed there. Well, her name printed there is not her signature, okay? They do the same thing in Canada, okay? That is not signed, okay? And so if you go and find those statutes and you look them up, you'll find that that's exactly the case. It's not signed by her. And so there is no royal assent. What happens is after it sits on there's a table they put it on for the Queen to review it and then sign it. And if she doesn't review it and sign it within a certain period of time, they presume that it's got royal assent. And the burden's on you to bring up the issue. And so bring up the issue. There is no royal assent. Just because it's sitting on that table for a period of time doesn't mean she assented to it, and it doesn't have her signature on it. And just start dumping on them on that stuff. Again, they don't have a shred of authority. Quote, the zip code divides the United States into 10 military venues called national areas. When a citizen receives mail from an agency of the federal government, such as the IRS, and the return address of the federal agency is a district within the regional area the letter was sent from. And on the address of the citizen it is sent to is the national area, the zip, in which it received the correspondence from the IRS. In other words, the correspondence was sent from one of the federal regional areas, a military venue, to one of the national areas, another military venue. Taxing districts are established within one of the federal regional areas, which places the collection of taxes under a martial law jurisdiction, unquote. Now, one of the things that you see them doing in the U.S. is they always make it interstate, okay? So then it falls into interstate commerce. In other words, when you get a letter from the IRS, 99.9% of the time, if you live in Arizona, the letter will be coming from Utah or California or anywhere but Arizona, okay? Now, the IRS has offices in Arizona. And so when you go online, you find out what their offices are, and you always make sure and send your mail to that office. If you're going to do something, you send it to that office, okay? So now it's not interstate commerce anymore, okay? And you know, there's a bunch of things that you can do to defeat this stuff. But really, the bottom line is they don't have a shred of authority, and that's really the argument is, where's your authority? You don't have any authority. You're operating under the color of law. There's no royal assent here. You're nothing but thieves. And you have to do other things like by protecting yourself. In other words, you don't have a bank account with a social insurance number or a social security number. There's a lot of things that you have to do to lay a foundation. You make sure that they don't know where you live. In other words, I always use a private mailbox. And what that does is if I start administrating them, if I start filing criminal complaints against them, it buys me time because they don't know where to find me. And once I administrate them enough, it actually worked pretty well for me in Arizona because they issued a warrant for my straw man's arrest. And we talk about that when I do the asserting sovereignty part of the private information share, because they issued a warrant for my arrest or my straw man's arrest, and so I filed a lawsuit against them. And I think I've talked about this other times, but anyways, I filed a lawsuit against them. What happened is they issued a warrant. I knew that they'd issued a warrant. And I was preparing a lawsuit, and it was on a Friday before Memorial Day weekend. And if you understand Memorial Day weekend, it's in May, and Monday is always the holiday. And so what happened is it was Friday. There's my coworkers. I was working at U.S. Airways at the time. They told me that it was this big guy looking for me. Well, I knew who exactly that was, and so I took I left work early that day, and I took a week's vacation, and I finished up my lawsuit and filed it. But then when I was driving out of the parking lot, I saw this guy that come driving in, and he had a yellow van, and it was all caged in inside. And so he was a bounty hunter. And the point is that I had served my notices on the chief of police, on the county sheriff, on the U.S. attorney, on everybody and their brother that I could think of, and none of them would have anything to do with it. They had to get a bounty hunter to do it because the cops wouldn't touch it with a 10-foot pole. And that's the power of those notices. You put them in a position that they have to honor their oath of office, and they will. But you gotta take lay the foundation. So, anyways, what happened is I filed a lawsuit on Tuesday because Monday was a holiday. I finished it up, and I filed it on Tuesday, and then I sent a registered letter to the chief judge of the Supreme Court, and I had filed a lawsuit. I named her in that lawsuit too because I had been administrating her and sending her notices and telling her that you get these criminals operating in the town of Florence. And so, anyways. what happened is I added her to the lawsuit, so I sent her a notice, and I said, I sent these other notices, and I told you about this, and I told you about this, and now these criminals have issued a warrant for the arrest of their straw man, and I demand that you quash that warrant for that arrest of that straw man. And I said, quote, because we all know that the corporate commercial agents, police in brackets, are too stupid to tell the difference between a sovereign living soul and a straw man vessel, unquote. And then I said, furthermore, I filed this lawsuit, and this is the case number, and you're named in it, and if you fail to quash the warrant for the arrest of this straw man vessel, it'll be further proof of your dereliction of duty to regulate your subordinates. And she quashed the warrant, and because I went to work after that, and nobody ever came looking for me. And it turned out in the lawsuit, the Attorney General responded for the Chief Judge in the lawsuit. I sued the Attorney General, too. But anyways, and essentially what that is a counterclaim, is what it is, if you think about it. And so, anyways, the Attorney General responded for the Chief Judge in the lawsuit, and the Attorney General said it's perfectly appropriate that I petition the Chief Judge to get the warrant quashed. And actually that warrant is still out there today, and I think that she didn't quash it. I think what she did is she issued a restraining order so that they didn't mess with me. They only looked for their straw man. And so, I didn't care who they messed with as long as they weren't messing with me. And so as long as I don't pull out their government-issued ID, and what happened is a couple of years later, I got in a car accident. This was back in 2010. I got in a car accident, and some lady made an illegal left turn and broadsided me, and so the cops came. And what happened is I never pulled out a driver's license, so I never pulled that out, but I did pull out a passport. And so based on that, they were able to pull up a birth date, and they pulled up that warrant. And this was, you got to understand, the town of Florence is the county seat for Pinal County, okay, and which is the head town in the county. It's where the county corporation headquarters is at, and it was the Pinal County Sheriff that came to the accident, and they're the ones that pulled up this warrant. And I heard them talking on the radio, and they said, we don't want to extradite. Well, I was in Pinal County. Why would they want to extradite? I'm still at a loss for that. And so they were basically telling the cops that they didn't want to talk to me, I think. But anyways, so and the county sheriff, they made all sorts of threats, but they never arrested me, and they never took me in there. And they said I needed to take care of it. They said it won't cost you $350. And yeah, that's right. It will only cost me $350, but it's the principle of the thing. I got to plead guilty to something against a straw man, and so I know that thing still exists. Matter of fact, I'm getting ready to serve a letter on the Attorney General and tell him to get rid of that thing. And we'll see how that goes. But so the bottom line is that if you bring up the right issues and put your public servants in the position of honoring their oath of office, it's fatal. It's the same thing here with the IRS, okay? What I do anytime I go anywhere is I start serving letters on the Chief Judge of the U.S. District Court in the area where I'm at, like Delaware. I'm in Delaware right now, so the Chief Judge of the U.S. District Court in Delaware got one of my letters, and so did the U.S. Attorney in Delaware got one of my letters, and the FBI Special Agent in Charge got one of my letters, and the U.S. Marshals got one of my letters. Now, if the IRS wants to do anything to me, they got to go to the U.S. Attorney. They got to go to the U.S. District Judge. They got to go to the U.S. Marshals, and none of those guys are going to want to have anything to do with it. And so, anywhere I go, if they want to do anything to me, that's what I do. And I also, if the IRS doesn't even want to communicate with me, and so I don't think they're doing anything anyways. But I always do it as a precautionary measure to put them in a position that these guys are going to be honoring their oath. And that's why they told me that I'm listed as sovereign in their system, I think. Anyways, let's go back to this topic at hand, which is military law, which is martial law. Everything's under martial law. Quote, the zip code divides the United States into 10 military venues called national areas. When a citizen receives mail from an agency of the federal government, such as the IRS, and the return address of the federal agency is the district within the regional area the letter is sent from. And on the address of the citizen it was sent to is the national area, the zip, in which he received the correspondence from the IRS. In other words, the correspondence was sent from one of the federal regional areas, a military venue, to one of the national areas, another military venue, taxing districts are established within one of the federal regional areas, which places the collection of taxes under a martial law jurisdiction. And that's, again, taken from the non-ratification of the 14th Amendment by Utah Chief Judge A.H. Ellett and this Dyett versus Turner of the Utah Supreme Court. Here's another court case, quote, "It becomes essential to distinguish between what is and what is not income, according to truth and substance, without regard to form. Congress cannot, by any definition it may adopt, conclude the matter, since it cannot by legislation alter the Constitution from which it derives its power to legislate, and which within those limitations alone that power can be lawfully exercised. Income is derived from capital, the gain derived from capital. Here we have the essential matter. Not a gain accruing to capital, not a gain accruing to capital, not a growth or increment of value in the investment, but a gain, a profit, something of exchangeable value severed from the capital, however invested or employed, and coming in being derived, that is received or drawn by the recipient for his separate use, benefit, and disposal. That is the income derived from property. Nothing else answers the description," unquote. Now, this court case has all sorts of bold, okay? It says derived from capital, the gain derived from capital in the court case. This is unprecedented in the courts. I looked this case up to verify it, and it's true. The derived from capital, the gain derived from capital is in bold and underlined in the court case. I've never seen that in a court case, but it is bold and underlined. They're tired of addressing the issue. And what they're saying essentially is that income is corporate profits. It has nothing to do with anything that we the people do. It's corporate profits. Evidence that there's a military occupation. Military script is circulated for money. Police use the rank structure of captain, lieutenant, sergeant. Police refer to us as civilians. Courts presume everything. Curfew is strictly under a martial law jurisdiction. State regional areas under metro government provide the military venue for peace officers to enforce martial law jurisdiction. And that's all taken from that Dyett versus Turner. This is a war over the intrusion of civil law upon the common law. The court in Diamond v. Harris called civil law statutory law superior equity. Quote, "It is difficult to see how the courts of this case are to ignore the common law as a rule of decision when it's made so by statute and adopt the civil law even though it has the merit of superior equity." And that's Diamond v. Harris, 33 Texas 634, 1830. And that's, again, all of that's taken from non-ratification of the 14th Amendment and that judge by Judge A.H. Ellett and Dyett versus Turner. Quote, "We can't even begin to count the number of times judges, lawyers, and statesmen have said there isn't any common law anymore. It has been replaced by statutes. They would be more truthful if they said there isn't any common law anymore. It's been replaced by martial law," unquote. And that's, again, taken from Dyett versus Turner and the non-ratification of the 14th Amendment. This case is really good, I got to tell you. I got a lot of this material from there. And he quotes a lot of other cases like the one that defines the three kinds of martial law, you know, and all that stuff. But those are other U.S. Supreme Court cases. Anyways, quote, "There is no common law of the United States as contradistinguished from individual states, and courts of the United States, instead of administering common law or any particular system, conform to laws of states where they are situated." And that's People versus Folsom, 1855, found at 5C 373. So, again, in the federal jurisdiction, there's no common law, but the courts of the United States recognize that the states have common law, and they will deal with that. Quote, "In the meantime, civil law was the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law, to have superior equity as the turnings on their head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what is called equity in its place," unquote. And that's, again, non-ratification of the 14th Amendment and Diet versus Turner, Utah Supreme Court. All these martial law statutes are a color of law. There is no Income Tax Act. There is no British North America Act. There is no Customs Act. There is no Immigration Act. When there's a defect in the legislation, it's unconstitutional. It doesn't exist. Quote, an unconstitutional act is not law. It confers no rights. It imposes no duties, affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Unquote. And that's Norton versus Shelby County, 118 U.S. 425, U.S. Supreme Court. Quote, absolute nullity, civil law, an act that is void because it's against public policy, law, or order. The nullity is non-curable. It may be invoked by any party or by the court. And that's Black's Law Dictionary, 8th edition, page 3391. And I got to tell you, I've seen lawyers go into court and say there is no contract, it's a nullity. And that's exactly right. When it's the sovereign, when it's one of we the people, that's why they have to create that Sestake Trust, because they know they don't have a shred of authority over a living soul. They have to create that fictitious entity. Then they have authority over that. And they're playing games to get you to be the surety for their fictitious entity. That's exactly what's going on. In the Alberta Judicature Act, Section 15, it says, quote, in all matters in which there is any conflict or variance between the rules of equity and common law with reference to the same matter, the rules of equity prevail, unquote. Well, that's essentially saying is that we're not going to pay any attention to common law, and that equity is the way we're going to do things, and that means they can do anything. And that's exactly what that case was saying a minute ago. Martial law is really no law at all. It's a dictatorship. Quote, what is called proclaiming martial law is no law at all, but merely for the sake of public safety in circumstances of great emergency, setting aside all law and acting under military power, a proceeding which requires to be followed by an act of indemnity when the disturbances are at an end, unquote. And that's found at 8 Attorney General's opinions, 365 and 367, February 3rd, 1857. Quote, but individuals when acting as representatives of a collective group cannot be said to be exercising their personal rights and duties, nor be entitled to their purely personal privileges. Rather, they assume the rights, duties, and privileges of the artificial entity or association of which they are agents or officers, and they are bound by its obligations, unquote. And that's United States versus White, 322 U.S. 694, 1944. And it's also Braswell versus United States, 47 U.S. 99, 1988. And this is what I was saying, is they're creating that fictitious entity, that Sestake Trust, because they know they don't have a shred of authority over you, and they're playing games in their court to get you to be the surety for their fictitious entity. And that's what this court case talks about. Quote, this power of admiralty jurisdiction is as extensive upon the land as upon water. The Constitution makes no distinction in that respect, and if the admiralty jurisdiction in matters of contract and tort, which the courts of the United States may lawfully exercise on the high seas, can be extended to the lakes under the power to regulate commerce, it can, within the same propriety and upon the same construction, be extended to contracts and torts on land when the commerce is between different states, unquote. And that's Propeller Genesee Chief et al. Versus Fitzhugh. And that's 12 Howard 443, U.S. Supreme Court, 1851. Quote, and it may embrace also the vehicles and persons engaged in carrying it on. It would be in the power of Congress to confer admiralty jurisdiction upon its courts over the cars engaged in transporting passengers or merchandise from one state to another, or over the persons engaged in conducting them, and denied to the powers of the trial by jury, unquote. And that's that same court case, Propeller Genesee Chief versus Fitzhugh, 12 Howard 443, U.S. Supreme Court, 1851. And so that's what they do. When you go and get a driver's license or you register the vehicle, you swear at the bottom of that form. It says, I swear under penalty of perjury that I'm a U.S. citizen. And that's where they get the authority, because it's only U.S. citizens that they have any authority over. And so you're saying under penalty of perjury, you're a U.S. citizen. Quote, Now, the judicial power in cases of admiralty and maritime jurisdiction has never been supposed to extend to contracts made on land and to be executed on land, but if the power of regulating commerce can be made the foundation of jurisdiction in the courts, and the new and extended admiralty jurisdiction beyond its heretofore known and admitted limits may be created on water under that authority, the same reason will justify the same exercise of power on land, unquote. And that's that same court case, Propeller Genesee Chief versus Fitzhugh, 12 Howard 443, U.S. 1851, U.S. Supreme Court. Quote, next to revenue taxes itself, the late extensions of the jurisdiction of admiralty are our greatest grievance. The American courts of admiralty seem to be forming by degrees into a system that is to overturn our Constitution and to deprive us of our best inheritance, the laws of the land. It would be thought in England a dangerous innovation if the trial of any matter on land was given to the admiralty, unquote. And that's Jackson versus Magnolia, 12 Howard 296, U.S. Supreme Court, 1852. Texas Administrative Code, Section 79.31, corporations. And then it says characters of print acceptable in names. Paragraph A, entity names may consist of letters of the Roman alphabet, Arabic numerals, and certain symbols capable of being reproduced on a standard English language typewriter or a combination thereof. And then in paragraph B, it says only uppercase or capital letters with no distinction as to typeface or font will be recognized. And that's what it's saying, okay? In other words, it's all block capital letters for corporations. Well, why do you think that they spelled a name on the driver's license in all block capital letters? It's because it's a Sesticate trust. It's not a living soul. It's a trust. It's a corporation, a fictitious entity. And that's why you have to swear under penalty of perjury that you're a U.S. citizen to get a driver's license. You're saying you're a fictitious entity. Quote, the court shall, subject to this section, take cognizance of and judicially proceed upon all and all manner of captures, seizures, prizes, reprisals made under the authority of Her Majesty and right of Canada of all ships, aircrafts, or goods, and shall bear and determine the same, and according to the course of admiralty and the law of nations, to judge and condemn all such ships, aircraft, and goods belonging to any enemy, country, or the citizens or subjects thereof, or any other persons. And that's found in Section 5.1 of the Canada Prize Act, okay? So a person is an enemy of the state. And again, if you look in the Interpretation Act of Canada, a person is a corporation. And so, again, you want to be, I mean, I don't know why anybody on earth would ever want to be a person. But, you know, people, you know, seem to want to do that all the time. I just can't believe it. Prize. This is found in Black's Law Dictionary, 8th edition, page 1078, quote, a prize is a vessel or cargo captured at sea or seized in port by the forces of a nation at war, and therefore liable to be condemned or appropriated as enemy property, unquote. And that's Black's Law Dictionary, page 3779. Prize court, a court having jurisdiction to adjudicate the captures made at sea in time of war, unquote. That's Black's Law Dictionary, 8th edition, page 1078. They're making war on us. That's exactly what they're doing. Actually, they're making war on corporations. And we're so ignorant that we go and say, yeah, I'm one of these corporations. Title 18, United States Code, Crimes and Criminal Procedure, Part 1, Chapter 1, General Provisions, Section 7, Special Maritime and Territorial Jurisdiction of the United States defined. The term Special Maritime and Territorial Jurisdiction of the United States, as used in this title, includes 1. The high seas, any other waters within the Admiralty and Maritime Jurisdiction of the United States and out of the jurisdiction of any particular state, and any vessel belonging in whole or in part to the United States or any citizen thereof. Right there. You're putting yourself, if you're a U.S. citizen, you're swearing the penalty of perjury when you apply for that driver's license or registration. You're saying that you're a U.S. citizen, and you're putting yourself in that Admiralty Maritime Jurisdiction. And that's why when you go into traffic court, they have a gold French flag hanging in the corner, and it's a kangaroo court. and the judge sits up there and says, the Constitution doesn't apply in here, and I don't want to hear another word about it. Quote, any of the following types of crimes, federal or state, offenses against the revenue laws, burglary, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame, and like offenses, extortion, swindling, confidence games, and attempting to commit or compounding any of the foregoing crimes, addiction to narcotic drugs, and the use of marijuana will be treated as if such were commercial crimes. And that's found at 27 Code of Federal Regulations, Section 72.11. Commercial crimes. All of that stuff is commercial crimes. Quote, the Admiralty from the highest antiquity has exercised a very extensive criminal jurisdiction, unquote. And that's United States versus Flores, 289 U.S. 137. Quote, Admiralty courts have a jurisdiction over contracts and torts and other special cases, unquote. And that's Waring versus Clark, 5 Howard 441, Genesee Chief versus Fitzhugh, and United States versus Flores. Quote, the criminal jurisdiction of the United States is wholly statutory. See United States versus Hudson, that's State versus Flores. And then, quote, it is natural to consider the vessels of a nation as parts of its territory, though at sea as the state retains its jurisdiction over them. This is the doctrine of the law of nations, unquote. And that's State versus Flores, 289 U.S. 137, 1933. Quote, the judicial power of the United States extends to all cases enumerated in the third article of the Constitution, but none other. It is not cognizable by the courts of the United States until it represents a case arising under the Constitution, laws, or treaties of the Union, or is the subject of equity, admiralty, or maritime jurisdiction, unquote. And that's Baines versus Schooner, James and Catherine, Federal Cases, page 576. Quote, it is true that the criminal jurisdiction of the United States is in general based on the territorial principle. Commerce and criminal statutes of the United States are not by implication given an extraterritorial effect. That's United States versus Bowman, 260 U.S. 94, that's U.S. Supreme Court. Quote, informations are filed in the Court of Exchequer for forfeiture upon seizure of property for a breach of laws of revenue, impost, navigation, and trade, unquote. And that's Kent Commentaries, lecture number 17. And that's Admiralty and Commerce, okay? And so the point is that an information is procedure, okay? If they're filing an information against you, you're in an Admiralty court. It's completely Admiralty. Quote, an information is a written accusation of a crime made by a U.S. attorney which permits the government, and this could be a U.S. attorney or Canada or England, whichever, which permits the government to prosecute an individual without benefit of a grand jury indictment. See, it's completely administrative. It has nothing to do with common law. It's Admiralty maritime law. An indictment is required in any case where a person is being charged with an infamous crime. The Supreme Court ruled in Macon versus United States, 117 U.S. 348, that any crime for which the punishment is imprisonment is an infamous crime. The use of information has a long history. For example, in the reign of King Henry VIII, writes Justice Blackstone in Book 4, Blackstone's Commentaries, page 310, a very oppressive use was made of them for something more than a century, so as to continually harass and shamefully enrich the crown, unquote. Also, the court observed in People versus Sponsler, that's 46 Northwest 50, quote, the oppressive use of this mode of prosecution by information occasions struggles to procure a declaration of its illegality, unquote. And what that's talking about is the Star Chamber. And short, prosecutions by information have long been a means of political suppression and intimidation. And it's completely an Admiralty maritime court. If they're filing an information against you, you're in an Admiralty maritime court. Quote, the use of information has a long history. For example, in the reign of Henry VII, a very oppressive use was made of them for something more than a century so as to continually harass and shamefully enrich the crown, unquote. And that's Blackstone's Commentaries, Book 4, page 310. Quote, the oppressive use of this mode of prosecution by information occasions struggles to procure a declaration of its illegality. People versus Sponsor. I guess I've already said that once. I'm going to fix that. quote, the law of the flag, maritime law, the law of the nation whose flag is flown by a particular vessel where it is registered, unquote, and that's Black's Law Dictionary, 8th edition, page 2591. So when they put a flag up in the courtroom, that's the law of the flag. And it's a gold fringe flag. They're telling you that this is a military court. And or a coat of arms, okay? This is the same thing. A coat of arms is a military symbol. And that's what they use in England and Canada, I can tell you right now. The right to be represented exists only in a military courtroom. That's found at 10 United States Code, Section 838A1. Quote, the accused has the right to be represented in his defense before a general or special court-martial or any investigation under Section 832 of the title as provided in this subsection, unquote. Anyways, I think we better wrap it up here. We're about at the end. We're about finished with my time. You can reach me. I have a website, www.sovereigntyinternational.info. I also have a group on this website, on These Changing Times website, called sovereigntyinternational.info, and I upload YouTube video links there, and also some documents are there. I've also got some private groups called Administrating Your Public Servants. There's one at Yahoo and one at Google, and I've uploaded a bunch of documents and have some instructions on what to do, and all my latest documents are up there actually too, in the postings. And I'm available for the contact there. You can also reach me at engineerwin@gmail.com. I'm available to do private information shares, which is largely all of this information, all in like a day or two. It'll probably take 2 days to cover, or a day and a half at least, because I've added a lot of material since the last time I did a private information share. But anyways, I guess we're about the end here. We'll turn the time back over to Kat.
Thank you very much, Glenn, and a great show, I must agree. My goodness, not only did you get common law information, vital information about the legal fraudulent system that's running, you also got a little bit of herbalism from Glenn. So, my goodness, he's a one with his information, I must say. And do remember that Glenn is with us 3 times a week. Yes, 3 times a week. He's back again on Sunday. Okay, so he's here on a Sunday, a Thursday and a Friday.